Commonwealth versus T.
Thank you very much. Thank you.
Ms. White?
May it please the Court, I'm Jane Larman White. I appear today on behalf of Daniel Key on appeal of his conviction in Hampton Superior Court for distribution of cocaine second offense. The defense at trial was one of misidentification. The circumstances surrounding his arrest, Mr. Key's arrest, were such as to call into question the identification of him at the scene.
But Ms. White, getting right to the question of the marked $10, how does the marked money, how would that have helped you? Doesn't its absence help you more in a way? Because then you can suggest that it never existed. If you had it, you'd be in a bad way.
Well, you know, Your Honor, that was sort of the end point of my argument about this, that premise is fundamentally offensive and in direct contradiction of the spoliation principle, that here you have evidence that the defendant was not permitted to confront, and so the assumption is that, of course, it was inculpatory, rather than a presumption of innocence, which would say it was exculpatory.
But doesn't that just provide you with a basis to cross-examine the police officer, which you can do?
Well, if the evidence had actually been there, instead of merely cross-examining the police officer who says, yes, it was there, even though they didn't produce the person who supposedly took the money from the pocket, and even though defense counsel's efforts to find out specifically what happened to that money when it was taken by Ackerman, it was, you know, this global thing, well, it was reused. And defense counsel said, well, was it immediately taken to the station? Was it immediately, he wanted to know. And those inquiries were cut off because the judge was impatient with it, and the confrontation right was certainly even more compromised than it was originally.
But I take it I certainly understand your point, but the evidence at trial included the evidence of one of the arresting officers, the testimony of one of the arresting officers, who said that he saw the other arresting officer take the $10 bill out of Mr. Key's pocket, and that he, the person who was testifying, looked at the $10 bill and found the markings on it that indicated it was the marked money. So there's at least testimony from a recipient witness as to what happened.
And I might flesh out that testimony and the circumstances surrounding that, was that the indications, the Commonwealth's evidence was that the money was specifically and intentionally marked so as to have the marking be non-discernible by a drug dealer holding it up to the light. And yet, this officer, Officer Trooper Fitzgerald, testified that although he never held the money, and although it was close to 10 p.m. at night, and there was no artificial lighting of such as would be used by a drug dealer attempting to discern the markings, that he nonetheless found these tiny sixes secreted in the trees on the back of a $10 bill.
Sounds like a great cross-examination.
That's what I thought.
Well, if the money had been produced, it would have been devastating and not merely great cross-examination. And that is the premise from which we must operate, rather than, oh, you got a bone here because you made more hay than was allowable if they had produced the money. And you cannot operate from the premise of guilt and the premise that the money was inculpatory rather than exculpatory. And that backs me up to the first part of this argument.
Can I just ask you a few other questions about that? Was there any inquiry at all about whether the markings on this bill were different than the markings that they had used in other cases?
This particular trooper testified that he always marked his money with sixes in the trees. That was the
So this would not have been the only bill that had those markings?
Well, the only money that he talked about was a $20 bill and a $10 bill, which he said that he gave to the middler in this case to get the money. He did talk about that he had $100 for the night, but the focus was on this, and he said he always marked in the tree.
Was there any testimony about his attempts to recover this money or identify it for purposes of the trial?
No, that was sort of this big missing piece. That officer went immediately to his car, an undercover car, and wanted to make tracks and get out of the area, and he left. And there was no testimony that he had the money. The testimony was that this person on the takedown team who came from around the corner cuffed the defendant, or maybe the other guy, the testifying guy, cuffed him. But anyway, the missing officer, who was not called, took this money out of the pocket. And as I explained, defense counsel's attempts to find out, well, what immediately happened to this money was rebuffed. It was merely this, well, we use it again that night. We have
How
to
is it
use
rebuffed?
again that night.
Rebuffed at trial, rebuffed pre-trial, rebuffed?
During trial, the defense attorney sort of belatedly became aware that the Commonwealth was not going to call the officer who actually took
Had
the
the
money,
money, yeah.
although he was listed on the Commonwealth witness list, and he was not available, apparently, according to the representations. He was in Framingham, and that they weren't going to make him come. So instead, the officer, the trooper who was there, who was part of this takedown team, was the one who testified that, oh no, he didn't get the money, and he didn't ever have the money in hand, but that he saw the money under the conditions that I've explained to you. But when defense counsel tried to say, well, the defendant was transported to the police station, right? And he says, well, I didn't transport him, but he was taken. He said, well, did the money go with him? And it was cut off.
Was there any inquiry as to whether they could recover that particular money, that piece of money, for purposes of the trial? Had he been asked that? Could we take a break during the trial, and could you go out and get that money and bring it?
No. The representation all along was that it was reused. We don't keep
Well,
the money,
reused,
it's
but it could be reused and retrieved, couldn't it?
There was no attempt to retrieve it. There was just complete, no, it's gone. We use it again. We are impecunious. We only had $100 that night. We had to make all these buys. We already lost 20 of the 100 because it was inside, and we didn't recover that.
Well, if the defense lawyer didn't ask him to go out and get the money and bring it back, hasn't this issue been waived?
No. And this does go back to my first point. The Commonwealth's premise is that unless the defendant can prove that it was exculpatory, he basically forfeits a right of confrontation about this. And that sort of standard is applicable, or at least is applied, in cases in which the defendant has been at fault in some regard, where, for instance, there's a vehicle that's germane to the investigation.
Well, in pretrial discovery, did you ever request in the pretrial conference report or anything this document, this $20 bill?
I think the answer is, to the best of my knowledge, no, that he was relying on the discovery which he was given, which was that there was no $10 bill taken into evidence at booking or anywhere.
So by the time of discovery, the bill, according to the police, is gone because it was reused that evening. So
yes.
Who knows where it is? And
in fact, the ridicule heaped upon defense attorney at trial by the officers is we aren't going to keep $10 or $20 or $2,000 in a vault to use at trial because we have to reuse that money. We don't
Well, they can
have money
photograph
to
it.
them.
and they didn't, right?
Was there a request, an inquiry as to why they didn't come into court as part of the discovery and say, look, let's photograph it so we can reuse this money because we don't have any money, we're limited in...
Every indication from any documentation is that as of that night, the money was not findable or discoverable.
Well, their answer to that would have been a good technique and probably certainly preferable. Their answer to that would have been they didn't have a photocopying machine in their subunit, but the answer to that is they could have gone to the Springfield police station and photocopied it there. Or they could have begun by photocopying it, at least.
And those were sort of the questions that defense counsel
Yeah, but
attempted
even if
to
they
find out.
began by photocopying it, which again would have been preferable, what's the proof that that's the $10 they used in this buy and that was the 10 that this defendant had on him when he was arrested?
There would be an opportunity to at least examine the sixes and how discernible they would be.
No, but you also have a chain of custody. You have a police officer swearing an affidavit saying, I took this $10 bill off this defendant at this time. That's no different than I took whatever I took off at that period of time. I mean,
Well, why shouldn't we treat this as we treat any other evidence that has been lost or destroyed by the Commonwealth in the course of an investigation?
Well,
Apply the regular standard.
first of all, what that standard is, I take issue with the Commonwealth. One is that the standard that the Commonwealth is seeking to apply in its brief is one in which the defendant is at fault in some manner. And in this case, my position is that the money was long gone and not findable before he ever got involved in the case.
The defendant's clearly not at fault. I mean, that's not an argument that makes sense.
The second,
But it's often that the Commonwealth, in fact, destroys evidence for a whole bunch of reasons, inadvertently. I mean, we've had countless cases.
well, the second issue, and this is another point on that continuum where I take issue, is that the Commonwealth is contending that the evidence was immaterial. And in fact, if the evidence were immaterial, then the Commonwealth should have had no problem in assenting to the remedy requested pre-trial by the defendant, which was to bar the Commonwealth from mentioning that evidence, the marked money. But that was not the position taken by the Commonwealth. There's an interesting case which is cited in my brief, although I didn't flesh out precisely this. It's the case of Commonwealth versus North, an appeals court case, and it talks about why, in that case, the missing evidence was not material. That happened to be something that would call into question the Commonwealth's theory about consciousness of guilt evidence in the case. The holding in that case was that the particular evidence was barely probative and it wasn't material because it was not relevant to disproving an element of the offense or to establishing a defense. And in this case, it has everything in the world to do with identity and
Establishes the
identification.
identity, certainly.
And that, in that regard, it was certainly material. This is the kind of case where the Commonwealth and the prior case law and jurisprudence of this court and the appeals court is that when the Commonwealth has evidence that they claim is both material and inculpatory and then destroys it and puts it out of the reach of examination by the defendant. And those are the cases in which, on which the defendant relies.
Material and inculpatory evidence put out of the reach of the defendant?
Claim to be inculpatory evidence, yes.
Okay. All right. So what cases are you relying on in that regard?
Well, there's Sassville was not particularly one. The particular ones are Glenowitz and White. There are others, but those are the ones that come to mind in that particular matter.
Okay. And what kind of formula should the trial judge use in those kinds of cases?
Well, another case that was cited is Holman, and it says, okay, you don't have to have reversal or there's not flat-out error warranting relief from the destruction of evidence so long as the defendant was free to inquire and comment about the loss of evidence and so long as other reasonable steps were taken to assure a fair trial. And that brings me to my second issue. The defendant here, I might add, as to the first issue, was not demanding dismissal of the charges, which frankly is the overreaching remedy asked for by a lot of defendants. But instead, he just wanted the Commonwealth not to be able to use this evidence that he hadn't been allowed to confront. Failing that, and that motion having been denied, he wanted a jury instruction. And I suggest that under Holman, this was the fallback position by which he could receive a fair trial. The Commonwealth's response to this, however, is that there was no foundation for this, and it applies the missing witness kind of rationale. Although I certainly cited missing witness cases, and there's a lot more of them than there are spoliation cases here in the Commonwealth, it's not quite the same. Because here, the analogy would be if there were a witness known to the Commonwealth and claimed to have inculpatory evidence, but the Commonwealth bought that person a one-way ticket to Rio and then refused to let the defendant know where the person was. In the missing witness case, the defendant most generally has the right to call that witness, to at least investigate and interview the witness and call the witness himself. And that is not the case when the witness is, officially dead for all of his purposes. So that's the distinction between the missing witness cases and this one.
I wonder if you're, in your answers to Justice Cordy's questions, if this case doesn't fail on the materiality. The case, you can correct me if I'm wrong, but it seems it's analogous to Ships, where the jewelry was destroyed and the jewelry had markings that might have been exculpatory, as here. Jewelry was destroyed prior to trial, and the court held that was not material.
Well, if the Commonwealth had not relied on the materiality of the evidence, it was material to them. It can't be material for their purposes of convicting him to corroborate an identification, and yet immaterial to the defense.
But where you have a
issue of
hand-to-hand buy, the officer identifies the person who was the middleman, or whatever he was. It seems that it's really not material, it's collateral. I mean, suppose he had a different $10 bill. So if he did have a $10 bill, it wouldn't prove he wasn't the middleman who was used.
But your point is the Commonwealth relied on that, correct?
They relied on it, and it certainly would, in as much as the officer's testimony was that the guy kept, the middler was being paid for his services and kept the 10 out of the 20 and the 10 that the trooper gave to him. So certainly, if he didn't have the marked bill, because there was no space of time in which he would have disposed of the 10.
He was in the apartment.
No.
He went in. After he got the 10, he went in, I thought. He then went in to get the drugs.
But the agreement was that the officer was paying him an extra 10 for his services to buy a $20 piece of rock, so that the 20 would have been turned over to the seller, and the $10 was, by the expert testimony of this witness, the middler's fee.
Right, but since the middler was out of the trooper's vision for some time, he could have given it to his girlfriend in the apartment. He could have, I mean, I don't think it's crucial where you have an ID of an eyewitness.
It was material enough for the Commonwealth, and by all of the evidence, the Commonwealth would have expected this person to have it. He was gone very briefly. The whole reason he was involved, according to the Commonwealth's theory, is that he was an addict who wanted to get the $10 for himself.
Yeah, maybe he used the 10 while he was in the apartment to buy some for himself. I mean,
I'm not
I understand
suggesting
your
that there's a
argument, yeah.
required finding of not guilty,
Yeah.
but this was evidence that was important to the defendant.
Thank you, Ms. White. Ms. Lynch?
Good morning. May it please the Court. Bethany Lynch, Assistant District Attorney representing the Commonwealth. It's the Commonwealth's position that the defense in this case, being misidentification, this $10 bill was relevant. We're not going to say that it wasn't relevant to the identification. It was not material. Because
Why not? Go ahead.
Under the definition of material, that it would create a doubt as to the defendant's guilt, the absence of a $10 bill in his pocket would not negate the identification testimony of the undercover witness, the undercover officer, who was never, except for the time...
Oh, surely it would create a doubt.
Well, not
Surely
if
it would create a doubt.
If he didn't have any money in his pocket, it wouldn't create that doubt.
Oh, no?
No, because we don't know what he could have done with the money when he went in that apartment. He was given $30 by the undercover. It wouldn't create a doubt such that it would create a reasonable doubt of his guilt.
Well, how do we assess that? In the mind of a juror, I think that would be extremely important, particularly in light of the circumstances here, where you have a dark night, you have lots of different folks around. The person who makes the buy leaves. He doesn't make the arrest. He's gone.
Well, he's
Other
not gone
people then
from
come
the
in and make
scene.
the arrest based on his description. I mean,
He's not gone from the scene. He never loses sight of the person that he engaged in this transaction with. They walk out of the alley. He walks towards his car as the takedown officers are coming. He sees the arrest. He's right there. So he
testified that he saw the arrest. It was the guy he had just left.
Yeah, he had left
the company of the defendant, but he had not yet left the scene. He left the scene after he saw the arrest occur.
What was the time period between when the officer gave him the 20 and the 10 and he returned?
The time that he went into the apartment, he described it, I believe, as between 15 and 30 seconds, 15 and 20 seconds. He went into the apartment.
Isn't that an argument the jury could say, you know, he's not going to take the time to go and, you know, secrete this money somewhere. He's not going to leave the money in plain view in the apartment.
Well, we don't know what happened in the apartment.
No, we don't know what happened.
No, because the officer was required to stay outside. The evidence
But the
in this
officer
case was...
testified, I know it was him because he had my $10 bill.
Well, he knew it was him because he was just standing right next to him. It was an
And you
eyewitness
say,
identification.
I don't want any evidence. Then I don't want any evidence because maybe it's dark, maybe it's whatever. I have no idea. But this officer says, I know it was him because he had my $10 bill.
Well, that corroborated his
You
identification.
bet it did.
But this
from the time that this officer began his interaction with this defendant, they were together on the sidewalk, they walked down an alleyway together into a courtyard. The defendant leaves his side for a matter of less than a minute to go and allegedly engage in a transaction to purchase narcotics on his behalf. He then returns to the undercover officer. They walk back out of the courtyard, back out of the alleyway, and onto the street. He was very aware of the defendant, and he was paying very close attention to
Why did the
it.
Commonwealth introduce this evidence?
Because the officer saw it. The officer who, the undercover officer testified that he physically marked the money. He had personal knowledge of that. He then said that he gave that money to the defendant. When the defendant is arrested, the officer who searches him, retrieves a $10 bill, and that is observed by his partner, and that $10 bill has the same.
If the evidence of identification is so clear, why does the Commonwealth try to, in the classic term, gild the lily? So we have a problem here. If it is so clear, why not just rest on that?
Well, and I would argue that the Commonwealth could have, but they were not required to. This was not evidence that should have had to have been excluded, simply because the Commonwealth did not have it in court. The Commonwealth is able to introduce evidence on a routine basis of things that people see but have not been documented. And that's what this comes down to. The bottom line is that the police officers had personal knowledge of the marking of the bill and the retrieval of the bill with the same marking. The officer who recovered the bill testified that he had seen the bill in the possession of Trooper Patterson, the undercover officer, with the 6 on it, and then he recovered a bill with a 6 on it from this, his partner, recovered the bill with the 6 on it from the defendant. They had personal knowledge of this. It was open to cross-examination. Their credibility was open to challenge.
Ms. White says the cross-examination was cut off.
Well, it was cut off because I'm not even going to agree that it was cut off. He had cross-examined. This was the 3rd police officer who testified about the money, and they were very brief testimony. One, in the direct of Trooper Patterson, he says, "I marked the money as I always do." The next officer said, "I saw him mark the money." The 3rd officer says, "I saw the money recovered from the defendant." The defense attorney, on his cross-examination, as was his right to do, cross-examined extensively about this money. Asked every single officer when they first saw the money, where is the money, do you have the money, was it marked into evidence, made a very, very specific point that this money was not retained and that, therefore, the officers couldn't corroborate the fact that it was found on the defendant. And by the end of the third, I believe it was the second redirect of the final officer, he's continuing to ask questions along the exact same lines that he's already asked this officer and other officers. And so I think that rather than characterizing it as being cut off, I think that the judge said the jury understands. We understand, and you've made your point.
Can I read this quote on spoliation? Which I think is important, and I guess you're suggesting the Commonwealth does not have this obligation. Once a litigant knows or reasonably should know that the evidence might be relevant to a possible action, we have imposed a duty to preserve such evidence in the interest of fairness. The destruction of relevant evidence is an unqualified wrong that has a pernicious effect on the truth-finding function of our courts. Why doesn't that apply here? That's a civil case. There's no liberty at stake there.
Yes. Well, I would argue...
Shouldn't the standard even be higher in a criminal case where the liberty of a person will depend on this evidence?
And I would agree that were this evidence something that were actually taken into evidence, then absolutely the Commonwealth could not destroy it. They couldn't lose it. They couldn't test it.
I didn't understand your answer.
At this point, this was never actually taken into evidence, this $10 bill.
Well, of course it wasn't, because
it was never entered into evidence.
It's been destroyed. It's been lost. It's been thrown away. It's been...
We're not talking about evidence that's being entered here. We're talking about...
evidence that can't be entered because it's been destroyed or lost or blown up or whatever.
It's evidence relevant to a cause of action, that the person knows is relevant to a cause of action. The police didn't think the recovery of this marked $10 bill was relevant?
Well, I
Why
think
did they
that
mark
they-
it if it didn't matter?
Well, I think that they would have recognized its relevance in corroborating their own identification, but not necessarily in proving the guilt of the defendant. It would have gone to corroboration, and the police officers...
Why is evidence relevant if it's not to prove the guilt of a defendant?
Well, it would be relevant in terms of an aspect, not in terms of an element of the crime, but in terms of the identification.
The only evidence the Commonwealth can put in is evidence that is relevant to determining the guilt of the defendant.
Yes, relevant, but more, there's degrees, I would argue, of relevance. There's things that are relevant directly to, like the drugs themselves would be relevant directly to his guilt, as well as the testimony of the of the undercover officer as to what actions were engaged in by the defendant would be relevant to the elements of the crime charged here, distribution of crack cocaine, where the marked $10 bill would be relevant, but relevant to the identification, to corroborating the identification of the defendant.
No.
To.
That is the identification of the defendant. I mean,
Well, the identification
it was
is
the
the-
mechanism that was used to identify the defendant. It was the best evidence that he was the seller of the drugs.
Apart from the eyewitness testimony, apart from the
Well,
undercover
eyewitness
officer.
testimony, Officer X, it was dark,
Right, but he was in his company for a considerable amount
I
of
know,
time.
I understand that, but as Justice Venus said, viewed one way, it was the best evidence because the officer said, I knew I had marked this, and I gave it to you, and you came back with it.
And that's true.
It's the best evidence.
It was relevant evidence of the fact that this man is the man that the undercover officer engaged in a
It's not his
transaction
twin.
with.
It's not his, similar-looking
Right.
cousin.
Right. As I say, it corroborated that identification because the undercover officer, as I said, was with him for a considerable amount of time, never lost sight of him on scene. He was also seen by the surveillance officer. The defendant was observed by the surveillance officer before he went into the alley with the defendant and as he came out of the alley again.
I take it,
So,
if you look at it the other way around, that the identification corroborated the marked bill. Right? So what we have here is a marked bill, let's assume. And it's the chain of command, no question, this was the bill that was given, this was the bill that came back. But the police officer who's giving the identification happens not to be available, but he's made a statement to somebody. That doesn't come in. Oh, it just corroborates the marked bill. It's relevant, but I don't have to cross-examine him. I don't have to really... You can't get that evidence in. Can you?
not without the officer. The officer
That's right.
could testify. But by itself, the marked bill wouldn't tell you anything. A person, if that was the only evidence, that doesn't tell you anything about the guilt of the defendant.
Isn't the question we have to decide here in relation to materiality, I'm quoting from the Ship's case here, it says that even those test results, that was a question of taking markings off jewelry by a chemical test, those test results would not have proved that the defendant did not commit the murders. That was the Ship's
Right.
case. So what, isn't the question we have to decide here whether the marking on the $10 bill, the absence of the marking would have proved that the defendant didn't commit the drug offense? That's the question we
Yes.
have to answer.
Yes, and that's
And your
why-
argument is that, because
would
that's
tell
the
you nothing.
materiality test, that we would have to say that the absence, that if you had the $10 bill without the markings, that would not have proved that this defendant didn't commit the drug offense.
Right.
Well, that's
That's
not
what
the
we have to
but that's
decide.
not the definition of materiality. It's evidence that would create a doubt. That is
Well,
materiality.
I think that also goes to whether the defendant can prove or can make any kind of a showing that this was an exculpatory piece of evidence. Because the presence or absence of the $10, if it was
can now
a
never be known.
different
Can
$10
now never be
bill.
known. Can now
Well,
never be known.
It can never be known. But if it were a different $10 bill, even for the sake of argument saying that a $10 bill was found on the defendant that didn't have a 6 on it, that doesn't exculpate the defendant.
It doesn't exculpate, but it creates
that's
a
the
reasonable
standard.
doubt. It creates a
Is-
doubt. Materiality is not evidence
Right,
that
but you
would
don't- first-
acquit the defendant.
Right, but first the defendant has to raise some evidence that's beyond conjecture that this is exculpatory evidence. Only after he meets that standard can we look at whether there was any culpability on the part of
But
the
isn't that so
defendant.
circular in this case? I mean, how can you do that here? How can you do that here?
Well, that's obviously that's what makes this case unique, was because there was no opportunity, at least for the Commonwealth. I understand the police as being part of the Commonwealth team. I understand that, but as for that moment, the prosecution could not have saved that money. There was no way there. All the cases that we have that are being relied upon are cases where the prosecution is the evidence is collected and
Why
put
could the
into.
Commonwealth not have saved this?
The Commonwealth wasn't there. The evidence was retrieved, the $10 bill was retrieved and reused before,
But it was
probably
retrieved
before
by a
he
Commonwealth officer, wasn't it? By a police officer.
It was, and it was returned to the drug fund and presumably used that very night. They were out doing a whole series of undercover operations, and they had $100 in marked money that they were going to use and use and use until it ran out. And after, this was their first buy, they used $30 of the $100.
Well, maybe we should tell police departments that's not the way to do it.
We could do that. It's never been
They can do
the
that, but
rule.
they can't rely on it. In other words, what's the purpose of it then?
Well, then why would they do it? Why would they have
Well,
marked
precisely,
money?
if they don't want to use it as evidence.
But they should be able to
They have it because-
testify
but
as to
they-
what they saw.
They should be able to testify as to what they saw, and I agree that's permissible. But I think a lot of this might depend on the extent of cross-examination that was
Right,
permitted.
and this was extensive.
And the defense attorney says that they were cut off. If they were permitted to cross-examine on the absence of it, then
Yes, the cutting off, if you will, was, as I said, the last witness on cross-examination. If you read the transcript, this was the primary focus of his defense, was that the police didn't preserve the $10 bill. They didn't videotape the undercover transaction. They didn't photograph what was happening. And he even implies through cross-examination that the police officer is wearing a wire for his safety, and he wants to know why the transaction wasn't audio recorded. So his entire defense was what the police didn't do and could have done in this case. And the money was huge. Show me the money was the foundation of his defense, and of his closing argument and of his opening argument. So there's no way that this was being withheld from the jury or anything. It was cross-examined based on what these officers saw. And if we want to make it so that if they don't keep the money, they can't use it in court, then it's going to undermine their ability to do their jobs in this case.
Well, there are so many ways to do this. I mean, we've just discussed some, but the very fact that it might be photocopied,
Well,
and therefore there is a record of precisely
even
what was
so-
taken from
But
the
even
pocket.
if it were
Photocopying
photocopied in the beginning,
before,
it wouldn't be
right.
any help. It wouldn't be any more help because it was photocopied in the beginning. But you don't have
Right, and
this now.
that's generally what is done, is that the marked money is photographed
Of course.
Was this evidence?
before they go
was
out.
this an evidence at trial that this is generally what was done?
It was that usually they photograph or photocopy beforehand, but they were unable to do so because they were at a subunit, a small office off-site.
Thank you, Ms. Lynch.
Thank you very much.
We'll take a short break.